should say commercial court is an important court to draw to your attention, because it's there where most high value litigation would go, where one of the parties is a foreign party. And in fact, it's very common for there to be a claim brought in the English Commercial Court in London where both parties are foreign, and they have actually stipulated under a choice of law clause and a jurisdiction clause that the English Commercial Court should actually look at the relevant case. In that forum, the judges will be slightly reluctant to suggest mediation, for the obvious reason that the parties engaged in that litigation are not ordinary citizens. You know, they haven't been knocked off their bicycle by a taxi driver. This is a shipping dispute, or it's some problem concerning the leasing of aircraft. It's some major commercial dispute, and the parties are not natural persons, they're companies. They are worth normally a great deal of money. They therefore have access to the best legal advice. They know what the portfolio of dispute resolution consists of. So it would be rather idiotic of the commercial court to say, have you thought about mediation? Of course they've thought about mediation, which is why they're in court. They've chosen not to mediate. Nevertheless, from time to time, even at this level, there is a window of opportunity. There is a perceived opportunity for mediation, and then the judge might, of his or her own volition, say politely to counsel, to barristers, let's just be clear, have you actually contemplated mediation? And then if one of the parties expresses enthusiasm, it might be possible for the judge, in discussion with the parties, to place the case on pause, to issue a stay, allowing mediation at the 11th hour to take place. So, ladies and gentlemen, to sum up on this, the position in England is that the judges are commanded to consider recommending mediation, but they will be reluctant to, thank you very much indeed, they will be reluctant to impose mediation upon two unwilling parties. Instead, this is an interaction which can be summed up as selective judicial recommendation of mediation, normally in response to a request for that to be recommended, a request by one of the parties. Now, mediation in England is supported indirectly by the threat that an unreasonable failure to consider mediation, might ultimately be sanctioned by an adverse costs order made by the court. So if one party says to the other, let's mediate, and the other party says, get stuffed, go away, not only is that impolite, but it might eventually rebound upon the party who has rejected mediation overtures, and if that party, as will normally take place, in fact loses the case, then that party might find that the costs that they have to pay to the other side are calibrated, are increased to reflect the fact that there has been, at this earlier stage in the dispute, what turns out to have been an unreasonable refusal to engage in mediation, which was requested by the other party. If the recommendation that there should be mediation is made not only by a party, but is reinforced by a judge, then parties' refusal even to consider that opportunity for mediation will expose that party to the same risk of an intensification, an increase of the costs that need to be paid if that party eventually loses the case. So I recommend to you this English technique of the Damoclean sword of costs as an indirect, I think, well-focused instrument to encourage parties to take seriously this dialogue that occurs concerning the opportunities for mediation and the further possibility that arises that judges might also recommend mediation during proceedings. It has worked quite well, and the threat of an increase in the amount of costs that need to be paid concentrates the mind of parties and lawyers wonderfully. Before I pass on to arbitration, let me just say that it goes without saying, and therefore I will say it, that negotiations for mediation are, of course, confidential. And more than that, in England, they are privileged. That is to say, one party who has engaged in mediation discussions cannot be compelled at any stage to disclose oral or documentary details of those negotiations in any other litigation, whether criminal or civil. There are one or two exceptions to that, but the basic position is that there is a very strong form of protection of the integrity, the confidentiality of these negotiations, whether they be negotiations for ordinary settlements or whether they be negotiations for settlement conducted through the mediation process. So, ladies and gentlemen, I have to be even-handed in giving justice both to mediation and to arbitration this morning. And so I pass on now to the subject of arbitration, of course, with your permission. Thank you. There is a long history, but we'll pass over that. To come up to modern times. Arbitration, of course, is rather similar to court adjudication, because the arbitrator or the arbitral tribunal is expected to be impartial and is expected to satisfy fundamental procedural principles, namely the duty to be even-handed, to listen to both sides, audi alteram partem. Of course, now, straight away, we notice a fundamental difference, which is that arbitration takes place behind closed doors. Arbitrators, at any rate in England, are expected to give reasons in support of their award unless the parties have dispensed with that requirement. The award becomes res judicata, and furthermore, the award can be recognised and enforced under the New York Convention, 1958, the year before my birth. Why do people go to arbitration? There have been studies in England, and the results, I think, are rather satisfying. Confidentiality is one of the main reasons given. That shouldn't surprise us. Secondly, this notion of control, autonomy, the power to choose the people who actually decide your case. And I say that with the greatest respect to any judges who are present. The power to decide, of course, the governing substantive norms, and in principle, the power to control the nature of the arbitral process. Another reason which is given is speediness, but I'm not sure that this is reality. And related to that, efficiency, but I'm not sure whether, at any rate in my jurisdiction, arbitration is any more efficient or certainly cheaper than court proceedings. Another reason given is finality, because the opportunity for appeal is significantly reduced if you proceed to arbitration as compared with court litigation. And a final reason which is given is that once you've got the award, you can dance around the world with it under the New York Convention 1958. To give you an example, there's no point getting a judgment from a Japanese or Chinese court and then seeking to enforce it in Japan or in China. You arbitrate, because they have no reciprocal recognition of civil judgments, but they will, as signatories to the New York Convention, they will recognise, subject to public policy of course, they will recognise each other's arbitration awards. So that's, I think, a vivid example of the supremacy, transnational supremacy of the arbitral process. As far as confidentiality is concerned, the English courts strongly recognise confidentiality, except when they find an exception, and the exceptions are starting to increase. One of the exceptions that has been recently recognised by the English Court of Appeal is that it will sometimes be permissible for a party to arbitration to reveal details of that arbitration process if that is necessary to avoid a potential injustice in related court proceedings to which that party is either a party or with which that party is closely connected. So the English courts are recognising that sometimes it would be unjust for a court, whether it be an English court or a foreign court, to be looking at a case without a vital piece of information which can be accessed, but only by lifting the veil on the arbitration process. So this is a judicial discretion to allow exceptions to the basic principle of confidentiality. There is no legislation on this. This is a product of case law. A recent Supreme Court decision in the United Kingdom is very important because it confirms that when you write your arbitration clause and when you define or stipulate who the arbitrators will be, or arbitrator, that you can do so by reference to the person's nationality and or to the person's religious affiliation. This is a 2011 case called Jivraj against Hashwani, in which parties to a commercial dispute in London had stipulated that the arbitrators should be drawn from